Hello, everyone. Hey. All right. Thank you for coming today. It's our second event for the year, and I appreciate you guys coming out. We have the pleasure of having Ilya Shapiro come out. He is he's a senior fellow in constitutional studies at the Cato Institute and the editor-in-chief of the Cato Supreme Court Review. A frequent contributor to many publications like the Harvard Journal of Law and Public Policy, Los Angeles Times, and a commentator on CNN and pretty much every other major TV network. He's filed over 100 amicus briefs with the Supreme Court. Previously, he was a clerk on the Fifth Circuit Court of Appeals, an adjunct law professor, and a special assistant and advisor to the multinational force in Iraq on rule of law issues. It's quite a resume. And so if you'll welcome him today. Well,
thanks very much. You left out the pinnacle of my career, which was my appearance on the Colbert Report, so y'all can Google that. It's my pleasure to be here. My wife's actually from Kansas, from Overland Park, and so I stayed with my in-laws this week, which was very nice. I also took in a Royals game, which is very nice, so thank you for arranging that during my trip. This topic I like to think that I come at about as objectively as anyone can. I've never used marijuana. I don't really have much interest in using it. Probably the only illegal substance that I've ever consumed is Cuban cigars. But this really, I think, demonstrates a lot of the tensions that we see between federal and state power in a host of different policy areas. Now, the Supremacy Clause, Article 6, Clause 2, says that state laws are trumped by federal laws with which they conflict. So that would seem to be the end of the story, right? The federal government criminalizes marijuana. Well, that's it, right? Well, not so fast. Because there are two important limitations to the Supremacy Clause. First, of course, is that the federal government is one of limited and enumerated powers. And so if what the federal law that's conflicting with the state law, if that goes beyond federal powers, then it's invalid, and the state law can survive. But secondly, and equally importantly, the federal government cannot what's called commandeer state officials to do their bidding, to enforce the law or pass new law or what have you. There were a couple of cases in the 90s that made this clear, that the federal government can enforce its laws in states, but cannot require local and state law enforcement or other types of officials from doing the same. Now, there are a lot of voluntary cooperation agreements between federal and state or local authorities in a variety of policy areas, from criminal justice, including drug laws, to immigration, to food and safety and agriculture. The federal and state officials cooperate in a whole host of ways. Typically, the feds offer states boatloads of money to comply with their programs, to voluntarily engage in the enforcement exercise. But again, they can't be forced to do so. Now, the problems, to the extent that they exist, the tensions in marijuana or otherwise, really are the Supreme Court's fault. Because in 2005, in the case of Gonzalez versus Raich, the court affirmed Congress's power to enact a ban on growing plants in your backyard and consuming them, and suggested that Congress's power to regulate or proscribe marijuana or other types of local economic activity was essentially unlimited. But Raich did not slow state legalization campaigns. At the time that Raich was argued, in 2005, 10 states had legalized medical marijuana. Since then, 11 more, plus the District of Columbia, have done so, while 16 have decriminalized. That is, being caught possessing marijuana is the same as a speeding ticket or some other minor infraction. And that includes 4 states that have decriminalized marijuana without having medical marijuana available, which is kind of interesting. And now, of course, 2 more states have legalized the weed outright. Colorado, right next door here, and Washington. And these state laws that legalize medical use or recreational use, will probably see both of those growing on the ballot next month in the election. Alaska, Oregon, and DC have legalization measures. And these sorts of provisions can't be preempted by Congress because of the anti-commandeering principle. That is, Congress cannot command states to pass certain kinds of criminal laws. Moreover, states hold the upper hand in terms of what kind of marijuana policy they want to have because of their greater relative law enforcement resources. The federal government has 4,000 drug enforcement agents, the DEA, worldwide altogether. And so even if it wanted to, it really couldn't act as the state drug police for a particular jurisdiction. Only 1% of the roughly 800,000 annual marijuana cases every year are handled by the federal government. So even though we think of ban on marijuana as being a Controlled Substances Act, kind of a federal policy, it's very much the states that enforce it. And even more than that kind of strict legal side, we have to look at state influences in other ways, in more subtle but arguably more significant ways. Robert Michos is a law professor at Vanderbilt who's done a lot of work on this. And he talks about how states have a strong say over the non-legal, the private forces that shape our actions, such as personal beliefs about social norms. So simply by allowing the use of marijuana for medicinal purposes or decriminalizing, or the few states that now have it for recreational purposes, states have fostered more tolerant attitudes, making it seem more compassionate, less dangerous or wicked or weird or perverse, and thereby softening the societal reproach that suppresses the use of the drug. And I think that's reflected in the rather dramatic shift in public opinion with regard to marijuana. It sort of parallels the drastic and quick change with regard to same-sex marriage. There was a poll done by Pew in April 2013. Things might have shifted a year and a half later, even more given the pace of change. But in April 2013, for the first time, a majority of Americans, 52%, favored legalization. This is up from 32% in 2002 and 17% in 1991. Pretty drastic change. And that includes 65% of millennials and 50% of baby boomers. I guess the statistic for my generation, Generation X, is somewhere between those two. But anyhow, only 32% think that marijuana is morally wrong, and 72% think that the cost of prohibition outweigh its benefits. That's a kind of a curious thing about the polling or about the American people, I guess. 72% think that the costs are greater than the benefits, but yet only 52% want to legalize. There's some empirical work to be done there. And the approval rates by party are also interesting. Again, this, give or take certain, margin of error and whatnot. Republicans approve legalization 32%, Democrats 59%, and independents 60 or 61%. So independents are actually higher than both parties. I don't know whether that's because they're libertarians or they just, people who don't like either party. That's, correlated to liking drugs. I just don't know. But this approval rate is across the demographic groups is generally consistent, regardless of whether people live in states that have decriminalized or not. Part of that might be a growing kind of information or knowledge or even sense about the state of our prison systems. In 2012, about 750,000 people were arrested for violating marijuana laws. It's roughly the population of Fort Worth, Texas, or the state of Alaska. About 12.5% of these marijuana arrests are for dealing or distribution. The rest are for possession. And indeed, possession arrests outnumber violent crime arrests by over 100,000. As of August 30th, 2014, just a month and a half ago, about 99,000 people were in federal prison for drug offenses. That's just under half of the total number of people in federal prison. And marijuana offenders represent 27.6% of drug offenders. So just over 10% of the entire population of federal prisoners are marijuana offenders. Despite levels of drug use relatively constant across racial and ethnic groups, black Americans are 4 times as likely as whites to be arrested for marijuana possession. So these kind of I think as knowledge of these sorts of things grows, combined with, just as with the debate over same-sex marriage, people now know gay people that they didn't before. I think now people know more people that I guess use marijuana occasionally and aren't dying in the streets or getting their 3-year-olds addicted or what have you. I think that's changing social attitudes. Okay, back to the legal side of this. Current federal law, as I said, Controlled Substances Act, passed in 1970, categorizes marijuana as a Category 1 drug, which means no beneficial use whatsoever, the strictest category. And there are only 2 exceptions to this federal ban. One is a compassionate use program that was started under President Carter, kind of akin to state medicinal marijuana programs, that allow patients to use for therapeutic purposes. Here's a piece of trivia that you can use at cocktail parties. There is the federal grow site for this program is housed at the University of Mississippi. So I guess there were some senators in the 70s that lobbied for this grow site at the University of Mississippi. Or maybe the senators from Mississippi were weaker than the other senators and it was foisted on. I don't know, but regardless, that's where it is. The program has stopped accepting new applications in 1992, however, and there are currently 8 people participating in this federal compassionate use program. There are also FDA-approved research studies, but again, very few of these. There were 11 approved between 2000 and 2009, so not really a wide sort of research agenda. And the federal government, regardless of which party controls the White House, has refused to expand legal access of any kind. There were kind of inklings or some noises about the very beginning of the Obama administration that policies were going to change, and enforcement priorities perhaps did shift in certain ways, but drug raids, marijuana raids are actually now up from what they were under the Bush administration. Again, perhaps slightly going after different types of marijuana users or distributors or what have you, but still not any sort of policy change. And the punishment under federal law when the feds go after people are pretty harsh. Simple possession is punishable by up to a year in prison and a minimum $1,000 fine. One prior conviction triggers mandatory prison time and raises the minimum fine to $2,500, going all the way up to cases involving 50 plants, which is, a lot. It's more than a couple of joints, but it's 50 plants. It's not a huge warehousing operation or what have you that carries a maximum term of 20 years in prison and a fine of $5 million. So what about the states? What have they had to say? Well, marijuana started to be banned by the states even before the federal government in the early 20th century. Marijuana was banned before cocaine and certain other so-called hard drugs were. You might recall the song, "I Get a Kick Out of You," right? There's that one line. I get no kick from champagne. That was originally I get no kick from cocaine. Coca-Cola, the original recipes had coke in them, that sort of thing. But anyhow, states started adopting bans. And that was about the situation until the early mid-90s when California started a wave of medical legalization. And as I said, 22 more states plus DC have passed that sort of legislation. For medical marijuana, there's sort of a common framework that's adopted. By this point, there are certain best practices. So prospective users have to have some sort of debilitating or chronic condition, cancer, kind of the rise of AIDS, certainly enhanced medical, how widespread medical marijuana was, and other diseases that produce pain, nausea, seizures, and spasms. Now, there are some doctors, apparently that have offices above dispensaries and things like this that you go into and you tell them you're sad and they'll give you a prescription or something like this. That is the sort of thing on which the federal government has been cracking down. So you've got to get this doctor's recommendation. Most states require people to register or have an ID card. Often that has to be renewed every couple of years. And there's a limit to the amount that you can possess, typically 1 to 3 ounces of usable marijuana or 6 to 12 plants. And these medical marijuana laws, once you get over the hurdles, provide typically pretty significant legal protections. Not just being exempt from arrest or prosecution for possessing, cultivating, or using, but also exemption from other types of civil sanctions, forfeiture, for example, which has been in the news a lot lately. If police seize marijuana, people that are lawfully having it, either medicinally or otherwise, they actually give it back to you, which is, just imagine this curious scene at the police station or what have you. It's like, oh, here's your cell phone back, your wallet back, here's your weed. Some states even bar landlords, employers, and schools from discriminating against qualified medical marijuana patients. So it's kind of become a protected class in some states. And caregivers and physicians are also typically afforded similar legal protections. Lawyers typically are not. And so whether you're talking about medicinal marijuana states, or especially now with Colorado and Washington, it's kind of a big gray area. I've spoken in Seattle and Denver, and the lawyers there are like, I have clients, I'm trying to advise them, but the state bar says I shouldn't be advising clients on things that violate federal laws. What am I supposed to do? It's a continuing thorny issue. At the same time, even though there's all these legal protections for users and their doctors, vendors don't always have the same sorts of protections. So there are states that have pretty broad legalization of medical marijuana or decriminalization, but it doesn't mean that it's easy to get. Very strict requirements sometimes that ban, up to and including banning the sale altogether. So you have you're a registered medical marijuana user, but you're only allowed to grow it yourself. You can't buy it from anywhere. So the voters in Colorado and Washington in the November 2012 election approved referenda to legalize recreational use. Interesting, very different political dynamic in both of these elections. The sheriff of King County, that's Seattle, one of the largest, most populous counties in the country, and so one of the most powerful sheriffs in the country, supported the initiative, saying that the drug war has failed and he'd rather use his resources and his officers for other priorities. In Colorado, the governor, the attorney general, and the top law enforcement officials were all against the legalization, although they said that they would abide by the voters' will. So in both of these states, again, there's still kind of growing pains and working out certain types of regulations, but generally possessing 1 ounce for personal use is no longer an offense. And there are continuing regulations being adopted for issuing and renewing licenses, security requirements, processing and sale of industrial hemp and other products that aren't for direct, recreational consumption. Driving under the influence, it's long been illegal to be driving while you're stoned, and legalizing the drug certainly hasn't changed that, but it's another problem of public policy implementation, because there's no equivalent to an alcohol breathalyzer, or even if you draw the blood of someone, it turns out a higher level of THC, the active ingredient in marijuana, in the blood doesn't indicate a higher level of impairment, because you're more impaired when that active ingredient has transferred from the blood to the brain and into your fatty tissues and things like that. So kind of counterintuitively, people are more impaired when they have when their blood perhaps isn't showing that. So there's kind of a debate among medical professionals about how to advise law enforcement regarding DUI in this context. There are also still issues, even though the state authorities in Colorado and Washington have changed their tax laws as well, so you can get a tax deduction for your inventory of pot and things like this, but the federal banking regulations have not changed. Now, there are some guidances, and some banks have decided to kind of go on a limb to service marijuana businesses, but that's not in the law. That's kind of, you know, a policy that could be changed anytime. They're on thin ground, and so the majority of marijuana-related businesses are majority cash businesses, which isn't helpful for preventing crime and things like this. So there's a lot of time that's spent on security and on running to the bank several times a day to make deposits and that sort of thing. So that's still, federal banking regulations aren't in the control of the state. So that's probably the biggest way in which the federal government, even bigger than its criminal law, that it's can control the spread of marijuana distribution. It took the Justice Department almost a year after the referenda in Colorado and Washington to come up with a policy of, you know, how we can legally treat this development. They decided that they were not going to sue in federal court to try to preempt the state law. They reserved the right to do so in the future. I don't think they'd be successful in that for reasons that I said. That, the preemption means that a state law has to be struck down because the federal law is in conflict. But here it's effectively the absence of law, the absence of criminalization. You can't force someone to pass a law to criminalize something. You can't force a state. So instead, the Justice Department notified the states that its focus would be on the following federal priorities: criminal enterprises, violence and firearms, distribution to minors, drug driving, use of marijuana on public lands and federal property, diversion to other states, very important here in Kansas, of course. I imagine the law enforcement officials all over Kansas have been briefed about, you know, different questions to ask and things to look for when they pull over cars on, say, the interstate that goes into Colorado and things like that. So it's changed policies in nearby states, and the federal government is certainly monitoring the spillover and tourism effect, what have you. And general public health and safety. So I suppose if there's the marijuana equivalent of kind of heroin addicts, you know, spaced out in the gutter or something like that, that would be a problem that the Justice Department would change policy about. The results are really, it's too early to exactly see, as a matter of either economics or sociology, what effect the legalization has had in those two states. Colorado's new law didn't take full effect until January of this year. Washington's in June of this year. In the first 2 months of the year, Colorado collected over $6 million in taxes, and they're still sort of adjusting how they're going to be taxing the sale, because it's hard to levy just a uniform excise tax given different concentrations, different types of products. You know, it's not just joints or loose leaf marijuana leaves for smoking. You also have edibles and vaporizations and a whole host of things that I didn't know existed and that continue to be innovated, I guess, as entrepreneurs enter the area. Estimates are that legalizing marijuana in Colorado has created about 7,500 to 10,000 jobs, provided the government nearly $100 million in revenue or savings from law enforcement, about half of which has gone into building schools, the authorities say. There hasn't been a real impact on levels of use or suicides, hospital admissions, the crime rate, or anything else. There's some decrease in traffic accidents. Again, that could have completely different causes. Some speculate that there's some substitution effect, that some people who would otherwise use alcohol at the margins are now smoking up instead. Maybe that's a novelty issue that will kind of change, but anyhow, we haven't really seen sociological issues. Again, it's still very early. So what can Congress still do if it wants to change its policy, or if it sees, you know, Alaska, Oregon next year come online, and more states, these are the trends, they want to stop that, or they want to control it further. I think the federal banking law is certainly a big area that the government has control in, and also, as I said, offering lots of money to change their regulations, or at least maintain them very strictly without further loosening of these laws. Congress could offer states not just money, but more regulatory power in various ways. You know, we're very concerned about drug use by children, so if you don't loosen your marijuana laws, we will issue more waivers from No Child Left Behind or Common Core or something like this. And those types of policies and offers would be probably end up in court and argue over whether that's coercive, because you can't have two unrelated things. NFIB versus Sebelius, the Obamacare case two years ago, went into that the government can't condition a whole bunch of money in one area on regulatory transformation in another area, that sort of thing. So that's, we'll see what happens. It's as states experiment, we'll see different reactions from the feds, I imagine. But this is, that's why this is just one example of a much broader phenomenon, situations in which states legalize private activity that Congress prescribes or restricts in some way. I think that dynamic is at play in everything from healthcare to immigration to guns. I mean, across a whole range of policy areas, we're seeing states push back in various ways, in part because Congress has essentially been paralyzed the last few years, in part because states are saying, we shouldn't have a one-size-fits-all solution. That, the laws in New York don't necessarily fit the laws in Montana and the laws in Kansas and what have you. So state laws that ban behavior that Congress legalizes, or obviously that the Constitution protects, cannot remain enforced. They're preempted or they're struck down as a violation of individual rights. But state laws that legalize behavior, where there's simply an absence of a law regulating or prohibiting it, have to remain valid regardless of what Congress does. States can't, however, Congress can't prevent the federal government from enforcing their laws. So, if a state passes a law saying someone who detains a lawful user of marijuana shall in turn be detained or arrested, can't have that because a federal agent arresting someone in Colorado or Washington is going about their business under the authority of the federal law. But it seems like because medical marijuana use has survived and thrived in the shadow of the federal ban, and now we have movements towards legalization in general, it seems like the war over medical marijuana is largely over, although skirmishes continue around the edges. And contrary to conventional wisdom, the states have emerged the victors. Again, if they want to have it. There's some states that don't, and that's fine. That's our federalism. So this area of policy shows that federal supremacy has its limits. Thank you.
Unlike last time, we're going to reserve a little bit of time for everybody to ask questions. I apologize, last time we didn't have time for that. But Professor Levy, Richard Levy is going to give commentary today. Many of you know him, but he is the J.B. Smith Distinguished Professor of Constitutional Law here, an internationally known scholar, and was a clerk for Richard Posner on the 7th Circuit Court of Appeals. So, thank you.
Well, first, John, thanks for the invitation to offer commentary. And I guess I should begin with a little bit of an apology to those of you who were expecting a heated debate, because I'm not really coming in here to disagree with Mr. Shapiro's basic point. So I agree fundamentally that state laws that repeal or fail to criminalize activities that are illegal under federal law are not preempted. I also agree that the federal government lacks constitutional authority to compel states to make conduct illegal if the state chooses not to make it illegal. And I also agree that as a practical matter, the federal government lacks the resources or the incentives to vigorously pursue minor marijuana violations that occur, violations of federal law that occur in states that have legalized marijuana for medicinal or recreational use. So instead, what I'd like to do is just add a few caveats to the general tenor of the discussion. The first caveat is de facto legal is not legal. So some of you may go to Colorado or Washington and you might be tempted to partake. Not that any of you actually would, but if you're tempted, you should be aware that this is still illegal conduct under federal law. Some of you may be looking for jobs. You might interview with the federal government. You might have some sort of background check that would be involved. And although it would be legal under state law, it would still be illegal under federal law. And that illegality doesn't disappear from the lack of vigorous federal enforcement of the law. I think also Mr. Shapiro mentioned the question of what's your ethical obligation when advising clients under circumstances where it's legal under state law versus illegal under federal law. You may have an obligation to advise people about that illegality. You may even have some obligation to refrain from assisting people in violating federal law. So that would be something to bear in mind. A related point in terms of de facto legal not being de jure legal is that having unenforced laws on the books invites discriminatory or abusive enforcement. So, and in this regard, Attorney General Holder's statements of federal priorities don't bind anybody. So the federal government is in a position to bring prosecutions against people who use marijuana in ways that are legal under state law for violating federal law. And they may be motivated to pursue these violations for reasons that are unrelated to the seriousness of the marijuana use or the extent to which that marijuana use violates the policies articulated by Holder. Outspoken critics of the government or the Attorney General's office, for example, might be more prone to being victims. So that's a second caveat. I think if you believe that marijuana should be legalized, you should not be satisfied with legalization at the state level, and that sort of full legalization will only come when there's legalization at the federal level as well. So a third point would be that I think I do disagree to the extent that Mr. Shapiro indicated that some state laws would be immune from preemption challenges. So preemption can occur when federal government completely occupies a field of regulation. Typically it does so explicitly or by adopting such pervasive regulatory statutes that there's no room left for any kind of state regulation in the area. It's also clear that there's preemption when it's impossible to comply with both the federal and the state law. But there's another kind of hazy branch of preemption that arises when the state law serves as an obstacle to the accomplishment of the purposes of the federal law. And some state laws that do more than just remove criminal bans from the books might be considered to be obstacles to the accomplishment of the purposes of federal law and therefore preempted. So one example of that would be a state law requiring officers to return marijuana that's been confiscated as a result of a search. Might be seen as encouraging, and in fact involving the state in providing an illegal substance to the owner of that substance. Now the federal government might not be able to direct the state what to do with it, but they could preempt a state law that said you must return it, which would then leave it to the discretion, I guess, of the state officers. Likewise, state licensing laws, although in one level they might prevent improper sale of marijuana or marijuana products, might also be seen as authorizing a violation of federal law in a way that encourages people to take action in violation of federal law. And so under at least some circumstances they might be vulnerable. Similarly, immunity from various kinds of private actions against marijuana users might be seen as encouraging violation of federal law by providing legal protections. And any state laws that related to, say, confidentiality of tax information, when that tax information might indicate a wholesale violation of federal law, might not stay on the books if the federal government sought the information that the state law purported to preserve or make confidential. These are just some of the examples of state laws that do more than simply remove criminal penalties and might be seen as encouraging use of marijuana in violation of federal law, and would therefore be seen potentially by the court as obstacles to the accomplishment and purposes of the federal statutory scheme. So those are my caveats. I do also then, before I close and open the floor to questions, want to reinforce a point that Mr. Shapiro made at the end and maybe amplify on that a little bit. These kinds of conflicts between federal and state law, there's a natural ebb and flow of conflicts over the history of the nation, depending on the extent to which the federal and state laws and policies tend to align or diverge. And I think right now we are in a time when more divergence between federal and state law is occurring and likely to continue to occur, partly because, as Mr. Shapiro points out, Congress is largely paralyzed. So as a paralyzed regulator, that means that people who are dissatisfied with the current state of the law must turn to state governments if they want to seek some kind of legal change, because realistically you're not going to get any meaningful change at the federal level. Part of the reason for that, though, is the sharp divide that's emerged between conventionally red states and blue states over matters of policy. And that divide, I think, also means that states are more likely to take more ideologically extreme policy measures, whether that's legalizing marijuana or clamping down on unlawful immigrants, or prohibiting the federal government from enforcing gun laws within the territory of the state, something that happened here in Kansas. So as the states become more ideologically pure and tend to move more in one direction or the other, their policy choices are more likely to diverge from the status quo of federal law, which is pretty much frozen in place by gridlock. So I think we're apt to see more of these kinds of conflicts over the next few years rather than less. So with that, I'll say that's enough and take questions along with Mr. Shapiro.
Any questions?
Would a change in the national law require congressional action, or because the FDA is in control of the Schedule 1, Schedule 2, Schedule 3 drugs, would the president direct, and then would there be a separation of powers issue created?
That's really interesting. I imagine the FDA can change the classification of the drug, but it can't decriminalize it and take away the federal criminal code relating to possession, distribution, and so forth. I'm not sure. I'm just speculating about the FDA's powers in that regard, but certainly, it's not just the FDA that decides to throw people in jail or prosecute or what have you. There's a U.S. code section that deals with it, and that requires legislation to change.
Could we see a cascade effect outside of marijuana to some of the other Schedule 1 drugs like LSD, or even into like lower opiates or something?
I mean, this is speculation on which ways social mores or political movements are going. I would imagine that you won't really see movement on other types of drugs until you have some critical mass of states that have legalized marijuana recreationally.
Cato?
I don't think anybody's shocked to know they had a real problem with prosecutorial discretion. I think that goes with the Fed's choices. So my question is, does it become an efficacy calculation of the policies if, you know, Levy, you were talking about if it frustrates the objectives of the federal policy, we might have an issue there. But don't the letters from Holder to the states and the USAs respectively sort of articulate what the objective is of the policy? And then it becomes, are the states, which method is better at identifying the solution to those objectives? I mean, so now Colorado can point to the decrease in teen usage and the drop in traffic fatalities and those kinds of things. Would the debate then be out of the legal realm and more about the efficacy of the things, and therefore who satisfies the objectives of the policy better?
Well, the debate's not in the legal realm right now because the Justice Department has said, we're not going to sue you. We're just going to, you know, here are our priorities, and we're just going to wait and see, and exactly see what the facts are on the ground. We reserve the right to change our policy or to sue you at any time. But for now, you know, that's the guidance, the policy guidance. I mean, it's not an argument that you can't preempt a state law by discretionary policy authority or guidance. That was, you know, the unanimous ruling of the Supreme Court in the Arizona SB 1070 case. You know, the "Show me your papers, please" provision. The poster child, the most controversial one, was actually upheld in Arizona's favor because the federal government's argument there was, you know, this goes against our enforcement priorities and resource allocations. And the court said no. I mean, that's not how you argue preemption. And the same thing here. So, you know, if we're seeing beneficial effects, and as you posited, I can't imagine that would change the government policy. You know, a new administration or a new attorney general might change the policy, but you know, all those things being equal, you know, beneficial results wouldn't change the policy. If we see negative effects, then, you know, we might see more confrontation.
So let me just add in, I think it's important to understand that the source of the policy that would preempt under an obstacle to the accomplishment of the object and purpose of the law is the statute, not Attorney General Holder's policy. Now, if there were a binding regulation promulgated by a federal agency, that might have preemptive effect, but the extent to which regulations unaccompanied by some sort of congressional specification of their preemptive force are themselves preemptive is harder to say. The second piece is, although the federal government has said we're not going to sue, other people have not. So it's not beyond the realm of possibility that a lawsuit might arise. Let's say I'm a private employer in Colorado and I've got a stoner for an employee and I want to challenge the laws that limit my ability to fire. I don't know whether Colorado has one of those laws. But as a private employer, I might go into court and argue that a state law that I don't like is preempted by federal law, and the fact that Holder doesn't care about it won't prevent me from asserting federal preemption. So it's not beyond the realm of possibilities that there would be a legal ruling on some of these laws.
Yeah.
What would this federal government sue Colorado for? Would it be for the, like, maybe there would be, like, the state law would be not allowing federal law, would be obstructing it? Or would they go maybe a different route, say, like, my thought maybe would be a little bit more creative, since Colorado is taxing this illegal drug under the federal government. Could the federal government sue Colorado for maybe something like money laundering?
Or even the forfeiture of the proceeds from illegal drug use.
That is creative. That's interesting. I mean, you know, if there were a law that said, you know, as I said, someone who's arresting someone for whatever's legal in the state is in turn subject to arrest, that would be a federal suit to say that's preempted it. And it would be along the lines of, you know, is this an obstacle to, as the professor said, to the vindication of the federal policy, kind of an implied preemption, also possibly like a dormant commerce clause theory maybe, of some sense, in the sense that Congress hasn't regulated, let me think, that would be like a inverse dormant commerce clause. I don't know, that's another kind of creative assertion, but I think that's the reason that the Justice Department decided not to just sue immediately because it wasn't completely clear without seeing exactly how the regulations work, which regulations they would go after, because it's not going to be a suit saying, court, give me declaratory judgment that Colorado has to unrepeal their law or something like that.
Well, so I think part of it depends on what the Colorado law says. So if the Colorado law says all statutes currently on the books prohibiting marijuana use are hereby repealed, and then they're repealed, there's nothing to preempt because there is no state policy. If, on the other hand, Colorado law says all marijuana use is hereby legal in the state, and all state laws to the contrary notwithstanding, you can use it. That law might be seen as encouraging violation and struck down. I think it's important to bear in mind that sort of whatever law the state has in fact enacted, if that contributes to marijuana use or promotes marijuana use, then it might be challenged because promoting marijuana use is contrary to the federal law, its purpose, which is to make it illegal so people don't use it.
So if there was a state policy, public service information campaign about marijuana use, maybe.
Yeah, well, I think the question would be, from my perspective, if you positively declare it legal, is that itself a public service announcement promoting use? So that would be the argument that you might make on the other side under those circumstances.
We've got a few more minutes.
So this may be a ridiculous idea, but if the law goes, say, 10, 15 years, the policy has been weird, more discriminatorily enforcing it, does that maybe open the door to like a 1983 action or an equal protection question that because of your enforcement history now after 15 years, you're being discriminatory and thus we can maybe attack the entire federal law?
I think so. I don't know about attacking I guess you could attack the whole federal law. I mean, the equal protection claims are raised based on prosecutions now in the drug and other contexts. I think, ultimately how this is going to play out is 10, 15 years from now, assuming trends continue, you will start electing congressmen and senators that have these attitudes as well. So it's not just, can't have, all 50 states legalizing, but yet Congress won't act at all. That doesn't follow. So that's probably the dynamic.
I do think it's important to understand bringing an equal protection claim based on discriminatory enforcement is really difficult, and you have to prove intentional discrimination, and it's hard to rely on statistical data to prove that. So McCleskey versus Kemp, the Supreme Court rejected statistical regression analyses that seem to demonstrate racial discrimination in the implementation of the death penalty because the regression analysis didn't prove that any particular case of the imposition of death penalty was prompted by intentional discrimination. So it might be very difficult, even though the data was fairly clear, indicating a racially discriminatory intent, that standing alone might not be enough to get you a successful equal protection claim.
It's just further what Chris was saying. In that case, then, well, obviously McCleskey sort of kills the racial argument, which you talked about, Mr. Shapiro, is 4-1 minorities getting arrested. And it's true even in the states that legalize, in fact, the difference has gone up. But if you had 10 years of them really not enforcing in the states, respecting the state law, would the onus then be flipped to the prosecution to sort of justify, in that particular instance, why this individual was prosecuted? Like if they were a lower level offender and you had chosen, discretion-wise to not prosecute 10,000 other people in the last 10 years for similar or worse offenses, would it then be forced on them to sort of justify why that individual was prosecuted?
Well, there are cases all the time where people who seem to be lower level get hit with harsher sentences than higher level because the higher level have cooperated sooner than the lower level people did. It's a tough question. Yeah, I don't think my criminal procedure, let alone practice knowledge, extends into that. I don't know, you have anything to
Well,
say?
so my observation on this one would be, there's a slim chance that a pattern might be regarded as shifting the burden to the prosecution to come up with an explanation. There's a similar doctrine dealing with peremptory challenges in jury systems where if you can show a sort of pattern of race, the burden shifts to the prosecution to come up with a race-neutral explanation. The evidence from that kind of a process, though, is any old explanation will do, and you're not really competent to be a prosecutor if you can't make up a race-neutral explanation that will get you past this kind of an inquiry. So Batson claims almost always fail because the courts are willing to accept all kinds of different explanations for why a prosecutor exercises this kind of discretion. And I think the same would certainly be true for the decision to prosecute a particular individual. So as long as you can come up with any kind of plausible race-neutral explanation, it wouldn't go anyplace.
And you have to remember that equal protection claims aren't just limited to racial or sex or the kind of known areas of category-based discrimination. You can have an equal protection claim for a class of one. That is, let's say there's some so-called known stoner that like the police just pick up every 2 weeks just because they can, and they don't really police the neighborhood otherwise. They just pick this guy up. Well, he might have a claim that he is unfairly being, the law is being unfairly applied to him. Another type of claim that might arise if, say, low-level users in one part of town are being arrested and those in the other part of town are not.
Well, I think we're pretty much out of time, so if you could give a hand to everybody. Thank you guys so much for coming, and thank Hot Box Cookies. They gave us these cookies. They have coupons down here. You should pick one up. You guys have a good day. Thank you so much.